Assalamualaikum. We are from Group 3. We will be present on the topic knowledge protection on the Intel Corporation. Intel Corporation is an American multinational technology company based in Santa Clara, California. Intel Corporation was founded on July 18, 1968 by semiconductor pioneers Robert Noyce and Jordan Moore, and widely associated with the executive leadership and vision of Andrew Grove. Intel combines advanced chips design capability with a leading-edge manufacturing capability. Intel is one of the world's largest and highest valued semiconductor chip makers. Intel supplies processors for company system manufacturers such as Apple, Samsung, HP, and Dell. Intel also makes motherboard chipset, network interface controller, and integrated circuits, flash memory, graphic chips, embedded processor, and other devices related to communication and computing.
Assalamualaikum. I will discuss about theory of knowledge protection. Knowledge generally can be defined as fact, information, and skill acquired by a person through experience and education of theoretical or practical understanding of subject. Knowledge is an intellectual capital of organization. For example, design formula, work of art and industrial process. This example of knowledge is an asset for the organization which can give a competitive advantage to the organization. However, this kind of knowledge sometimes will cause other parties such as competitor to copy the information or to steal the idea of knowledge. So in order to avoid this kind of problem or situation, the organization can use several knowledge protection to protect their knowledge assets such as product, service design, and formula. Knowledge protection consists of copyright, trademark, trade secret, and patent. Okay, the first one is copyright. Copyright is a protection given to work that have been expressed in a physical form. Usually, a composer, author, and director will use copyright to protect their work, for example, song, books, movie, and other work of art. Secondly is trademark. Trademark is protection given to word used in the organization. The word that have been trademarked cannot be used by other party to promote their product or service using the same word. For example, Nike, Microsoft Word, and Subway. Usually, the word TM will be visible in every word that have been trademarked. Service mark is similar to trademark, but service mark is used for service instead of product. For example, FedEx, Walmart, and McDonald's. We move to the third knowledge property, which is trade secret. Trade secret is protection given to valuable business information from being used or copied by others. Any kind of information can be protected as a trade secret. For example, formula, manufacturing procedure, computer program, and also technical design. Usually, organizations use trade secret to protect their unique and rare information. This information usually have economic value and also competitive advantage. For example, Coca-Cola use trade secret to protect the information about formula of making the drink. Lastly is patent. Patent is protection given to property that related to invention, and the invention must be disclosed to the public. Material that can be patented such as machine, manufacturer article, industrial process, and chemical composition. Okay, there are three types of patent, which is design patent, utility patent, and lastly is plant patent. Design patent is for invention of new design for article manufacturer. The invention must be ornamental and original. Utility patent is for invention or discovery of new useful machine, processes, and improvement method. And lastly, the plant patent is for reproduction of new variety of plant.
And now I'll proceed to the significance of patent.
A patent is an exclusive right granted for an invention. It provides patent owner with the right to decide how or whether the invention can be used by others. In exchange for this right, the patent owner makes technical information about the invention publicly available in the published patent document and registration. And these are the significance of patenting one's work. First of all, the owner or inventors have the right to stop others from manufacturing, copying, selling, or importing the patented goods without the permission of the patent holder. This is due to the reasons that most inventions involve considerable research and development, investment, and efforts. Patenting an invention serves to prevent competitors from simply copying or reverse engineering the invention and thereby appropriating those R&D efforts for their own. Secondly, patent can help to reduce competition. Patent may serve as barrier to entry for competitors who are intent to enter the market for the patented design or service. In this sense, other competitors may consider the risk of patent infringement is greater than the rewards of the potential profits. Thus, the patent helps to ensure that the payoff from the R&D and the patent owner's competitive advantage are maximized. Thirdly, the patent holder has exclusive or commercial right to use the invention. The patent holder can utilize the invention for his or her own purpose. The patent holder can license the patent for others to sell, and it provides revenues to business by collecting royalties from the user. The exclusive right to commercially exploit an invention provides the patent owner with the legal right to stop others from making, using, or selling the patented invention and the right to collect damages for such unlawful activity. Lastly, patents reward investors with big discoveries. Patents are also valuable for generating interest and investment in new and growing business. This is particularly important for companies attempting to establish themselves in high-tech industries, and patents also are partly responsible for advancement in medical science, biotechnology, drug chemistry, and computers.
Background of patent by Intel. Patent systems are the cornerstone of protection of the rights of innovators, but also must keep pace with evolving technologies and the changing needs of investors and producers. Questionable patents force companies like Intel to divert valuable resources to litigation that might otherwise go toward new product, research and development. This diversion of resources imposes an innovation tax that increases cost to consumers. Dedicated patent examines to the best work possible under difficult circumstances, but outmoded procedures, insufficient warning, insufficient training, and lack of resources result in a substantial number of problematic patents issued each year. When problematic patents end up in court, the fairness and efficiency of a country's litigation rules are major factor in whether the lawful rights of innovators and the interests of society in deploying new technologies are properly balanced. Intel works closely with policymakers to strengthen the protection of intellectual property and modernize patent systems. For example, in Europe, work is ongoing to develop a European Community patent, a major goal of which to simplify filing and examination procedures and facilitate the evolution of common European patent law. And another example, in Asia, work is underway in China, India, and other countries to adopt rules governing patentability of inventions that strike the proper balance between the rights of innovators and the interests of society. These worldwide efforts are essential for fostering technology development and achieving commercialization of new technologies. Done.
Implementation of knowledge protection by Intel. Intel depends on sound patent system worldwide. Why Intel choose patent? First, to protect intellectual property. Second, enable development of new technologies. Third, to improve the quality and the reliability of patents. Fourth, help World Trade Organization (WTO) conform their patent laws to WTO requirements. Fifth, develop procedure to lower the cost of resolving patent disputes, and lastly, to ensure the interests of patent holders and good faith manufacturers are properly balanced through fair litigation rules. The issue that Intel faced by implement patent. The first issue is abusive patent litigation is growing fast in America, US. Patent litigation rules do not provide a neutral forum by resolving disputes, but instead encourage that filing of lawsuits and winner-take-all strategies. Patent speculators take advantage of these imbalances the law to leverage high settlements. The US Supreme Court recently took important steps to return balance to the American litigation system, but a legislative solution would provide more certainty to industry participants.
The second issue is implementing patent. For example, implementing patent reform in Europe. There is a need for simplified and application management resources producers in Europe to facilitate securing patent rights in as many countries as possible for the most reasonable cost. Yet, some substantive improvement in patent law which Intel supports must be carefully balanced to ensure that Europe does not create or recreate incentives that encourage patent speculation and frivolous lawsuits, which would serve to undermine economic growth and the deployment of new technologies.
Next, the third issue is implementing patent reform. For example, in Europe, there is a need for simplified filing and application management procedures in Europe to facilitate securing patent rights in as many countries as possible for the most reasonable cost. Yet, substantive improvement in patent law, which Intel supports, must be carefully balanced to ensure that Europe does not recreate incentives that encourage patent speculation and frivolous lawsuits, which would serve to undermine economic growth and the deployment of new technologies.
The last issue is Intel faces some risk that it will be sued for patent infringement. Intel would use its intellectual property rights to negotiate cross licenses and to defend itself for infringement. And now we come to the suggestion on how Intel should improve their knowledge protection. Our group has listed out a few suggestions that can be used by Intel in order to improve their knowledge protection. Okay, in developing their products and delivery services to the customers, Intel has their own strategy in product development and product management function. For example, one of their strategy development can be observed through the Intel product life cycle, which it has 4 phases. Those phases are the exploration, planning, development, and production. In order to protect all kinds of strategies that are established in those phases, Intel can use trade secret system. This is because it helps to protect the confidential information within the organization from the knowledge of public or their competitors especially. Okay, the way on how Intel designs their products and establish strategies on how to attract more users are part of their confidential information. It is also the knowledge that should be protected by Intel. Thus, Intel can use trade secret as one of their strategies under knowledge protection. Let's move to the second suggestion, which is Besides, Intel also had their own name and symbol that helps in presenting their company in the market operation and enables their company to be commercialized among the customers. The word Intel as their corporation name and their logo need to be protected under the trademark system. Trademark will help Intel Corporation in protecting their logos as it created the image of the company. Their logos is the brand identities and trademark system provides legal protection against unauthorized use of the trademark. Other than that, it also can assist Intel in keeping the identity of their brand different from other organizations in digital industries in the market. Once Intel had registered their symbol and trademark, it will be as one of the strengths as other competitors cannot interrupt their sales and copying their brands. Next, Intel can improve their knowledge protection by developing or design new product with the latest invention. As we know, Intel is a company which design software, processor, chipsets which help in store data of its users. Upon that, Intel should upgrade the system of the software and chips with the latest invention. This is under the role of R&D department, which they have to make more research in order to create new software which is hard to be copied by other organizations which in the same industry. Hence, this will help Intel in protecting their knowledge or intellectual property. Okay, so these are the suggestions provided by our group in order for Intel to improve their knowledge protection. Thank you.
In conclusion, intellectual property rights are one of examples in knowledge protection that are crucial to protect the investment that companies and individuals make in developing new products and ideas. It includes patents, trademarks, copyrights, trade secret, know-how, and mass work rights. Intel depends on sound patent system worldwide to encourage innovation by allowing a patent holder to protect his or her invention. A patent is an exclusive right granted by a country to an inventor, allowing the inventor to exclude others from making, selling, or using his or her invention in that country during the life of the patent. Another important of knowledge protection are to improve development strategies. These include helping identify cost-effective and sustainable mechanisms for poverty alleviation. Here, Intel implement patent reform in Europe. There is a need for simplified filing and application management procedures to facilitate securing patent rights in as many countries as possible for the most reasonable cost.